Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.
People v. Rakeem Douglas, decided October 24, 2023. Singhas, J. During an inventory search of defendant's vehicle, conducted pursuant to the New York City Police Department's, NYPD, standardized, written inventory search protocol, the police recovered a firearm. Defendant contends that this protocol, on its face, violates both the federal and state constitutions. We hold that defendant's arguments fail to overcome the people's proof establishing a valid inventory search protocol. 1. In October 2015, two NYPD officers observed defendant Rakeem Douglas commit multiple traffic infractions while driving. The officers stopped defendant, discovered a gravity knife in his pocket, which was illegal at the time, and subsequently arrested him. Defendant and his vehicle were transported to the precinct, where the officers conducted an inventory search of the vehicle, during which they recovered a firearm from the trunk. The police vouchered the firearm, the other items located in the vehicle, and the vehicle itself. Defendant moved to suppress the firearm, arguing that the NYPD's inventory search protocol was unconstitutional because it gives officers too much discretion in conducting inventory searches and that the searching officers failed to create a meaningful inventory of defendant's items. At the suppression hearing, the people introduced the NYPD's written inventory search protocol as set forth in Section 218-13 of the NYPD Patrol Guide. The protocol instructs officers to first search the interior of the vehicle thoroughly, including any area that may contain valuables. The protocol lists 10 areas within the car that must be searched, such as the glove compartment and trunk, but does not limit the searching officers to those spaces. Second, Section 218-13 directs officers to force open the trunk, glove compartment, etc. only if it can be done with minimal damage except in particular situations including where officers reasonably suspect that the item contains weapons, explosives, hazardous materials or contraband. Lastly, the protocol requires officers to remove the valuables from the vehicle and invoice, or voucher, the property on a specifically referenced invoice form. Section 218-13 instructs officers to list property of little value inside the vehicle, within reason, in their activity log and cross-reference the property to the invoice number covering any valuables removed. Both officers testified that the purpose of an inventory search is, in part, to secure a defendant's items. The arresting officer further testified that it is an officer's duty to safeguard a defendant's recovered items prior to vouchering the items. Supreme Court denied defendant's motion to suppress, concluding that the NYPD's inventory search protocol was constitutionally sufficient, and the officers acted in accordance with the protocol in executing the inventory search. Defendant subsequently pleaded guilty to criminal possession of a weapon in the second degree and was sentenced, as a second felony offender, to a determinate prison term of 6 years followed by 5 years of post-release supervision. The appellate division affirmed the judgment, agreeing with Supreme Court that the officers followed a valid procedure for an inventory search of defendant's car. Here, defendant concedes that the officers complied with the challenged protocol and has otherwise abandoned any as-applied challenge. 2. Following a lawful arrest of a driver of a vehicle that is required to be impounded, the police may conduct an inventory search of the vehicle. People v. Padilla. An inventory search is a search designed to properly catalog the contents of the item searched. People v. Johnson. Because a warrant based on probable cause is not required to execute an inventory search, any inventory search must be conducted according to a familiar routine procedure. Gallick, citing Colorado v. Bertine. An inventory search procedure must be designed to meet 3 specific objectives: to protect the property of the defendant, to protect the police against any claim of lost property, and to protect police personnel and others from any dangerous instruments. Johnson, see also Lafayette. The protocol must limit the discretion of the officer in the field. Gallick. There is no requirement that an inventory search protocol be written, and courts will not micromanage the procedures used to search properly impounded cars. People v. Walker. Reasonable police regulations relating to inventory procedures administered in good faith satisfy the Fourth Amendment, even though courts might as a matter of hindsight be able to devise equally reasonable rules requiring a different procedure. 13. It is the people's burden to establish the validity of the protocol itself, specifically, that the procedure meets those three objectives and sufficiently limits the discretion of searching officers. See Johnson. The people must also demonstrate that these particular officers conducted this search properly and in compliance with established procedures, quoting Gallick. Here, the people sustain their initial burden of demonstrating that the protocol meets the constitutional minimum. Walker, see People v. Padilla. Accordingly, the order of the appellate division should be affirmed. The law permits warrantless inventory vehicle searches of impounded vehicles for limited purposes of protecting property, insuring against theft claims, and protecting officers and others against dangerous items. The prosecution here failed to establish that the guide, on its face, adopts a constitutional method for accomplishing these limited objectives. Order affirmed. Opinion by Judge Singas. Chief Judge Wilson and Judges Garcia, Canataro, Troutman and Halligan concur. Judge Rivera dissents in an opinion. Decided October 24, 2023.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law